Bienvenue à tous et à toutes. Welcome to the College of Europe European Legal Studies Department for our webinar today. A welcome to our very distinguished speakers, our students, and also to the wide audience who is following through stream. The topic clearly sparks a lot of interest. We have near 1,000 registrations this morning, and it was still running up towards this evening. In particular, also, I would like to welcome to the College of Europe Professor Daniel Sarmiento, who is the chair of our first session and who is sitting already ready up front. Professor Sarmiento, as you probably all know, is editor-in-chief of EU Law Live, with whom we are very happy to organize this event today. So welcome to the college. We are happy to host this joint event. Today we have a panel discussion on a very important topic for us lawyers, but for all citizens, EU citizens, world citizens alike. Today we have a webinar, a panel discussion on the rule of law. And more specifically, as you all have seen the title, a panel discussion on the rule of law conditionality in the wake of very much awaited judgments by the Court of Justice just last week. Today, the topic of the rule of law is even more important than ever before. We all woke up this morning with devastating news of Russia invading Ukraine. Now, we have war in Europe again, at the outskirts of the European Union. This is of concern to us all. And if we needed reminding, it shows us that our democracies are fragile, that peace, even in Europe, is fragile, and that the threats to our democracies, to our peace, and to our rule of law are both external and internal. Now, whilst the eyes of the world today are, of course, on the external threats to our peace and security and our democratic societies in the European Union and on the European continent, today here we will focus primarily, but not only, I would say, on the persisting internal threats to the rule of law. But there is a link, of course, between both. The rule of law is, of course, what we as lawyers cherish most, and it's probably also where we can be most useful. Respect for the rule of law. All lawyers know and have learned from the very early stages that this is what legal studies, what the law is all about. So not surprisingly, respect for the rule of law has always had a prominent place in the curricula of lawyers, whether at the College of Europe or in national universities. Respect for the rule of law for European Union lawyers is even more crucial because we all know that respect for the rule of law is and continues to be a founding value of EU membership. It is a founding value also of the European Union as such. Unfortunately, however, we all know that over the past couple of years, and not just today, the rule of law can no longer be taken for granted. And that whereas our studies and our research, and also the case law of the Court of Justice, was focused on respect of the rule of law, increasingly, we have the shift towards how to uphold and maintain and promote the rule of law. And this is also what we are dealing with today. We are increasingly facing what we call democratic backsliding, even in our member states and beyond. So the questions arise, of course, as of when do states start backsliding? Are we not too late in trying to respond until the facts have already happened? How can we prevent more and better that backsliding effect? What are the root causes of backsliding? How can we stop it? And how can we prevent it? Now, all of those questions are fundamental societal questions that we have in Europe and beyond, and have also been very much the focus of our research in the recent years. We have published a book and held a conference in 2018 here in Bruges with the collaboration of a lot of academics and professionals, called Constitutional Democracy in Europe. And we called it the future of constitutional democracy in Europe. Because of course we were supposed to have it, but we thought the challenge was how to keep it and to maintain it also for the future, for the younger generations. Now, I would like to link back again to what we said then about constitutional democracy, because we use constitutional democracy in a thick sense, precisely to include the three fundamentally associated and indissociable concepts of the rule of law, rather than the rule by law, of constitutional democracy in the strict sense, and respect for fundamental rights. What do we mean by that? Safeguarding the rule of law, not the rule by law. Meaning that you settle disputes, not by force, not by military force, not by economic force. You settle disputes on the basis of pre-established legal rules. Not the rule of the mob, not the rule of the majority. A predetermined set of rules that you will apply to settle your disputes. And those disputes are settled by independent judges. Independent judges, very important. Not judges allocated from case to case or having been put into place by a certain regime. Independent judges to deal with a dispute. And there is where the rule of international law comes into play, but also, of course, for the member states, the constitutional democracy rules. You should abide by the rule of law. You should, of course, in particular, abide by the rule of constitutional democracy, of constitutional rules, of rules with constitutional value. And you know that we have many of those in the European Union. Professor Garben otherwise can tell you. Now, what does it mean to abide by constitutional democracy rather than just plain democracy? It basically means that you shield societies from accidental majorities that could arise through majority voting. It means that in a constitutional democracy, you have in place essential procedural safeguards so that the essential rules of society will not be turned over on the basis of such an accidental majority. And it also means in a constitutional democracy that you do not only listen to the bullies, to the majority, but that you especially also have attention for rights of minorities. And when we talk about minorities, then immediately we come to our third indissociable concept, which is respect for fundamental rights. Respect for fundamental rights, which falls apart again in two sets. First of all, individual human rights and minority rights. We all know all are equal before the law. All benefit from equal protection of the law. And also, and very importantly, none is above the law, whether you are a citizen or authority. But we also have democratic principles to respect as part of our fundamental rights, and we have to protect them and respect them consistently and constantly. And here, in the past, we have guarded against what we call the democratic paradox, meaning that democratically elected institutions or authorities use that power of being democratically elected in order to undermine democracy from within. And hence, again, the importance of constitutional democracy. So all of that is linked up. So we have major threats and challenges. also within the European Union. Now, of course, we have tools and remedies in the treaties to try and tackle backsliding in terms of constitutional democracy in the thick sense, in terms of respect for the rule of law in the thick sense. Of course, we have Article 2 of the treaties, which says that everyone should respect the values, and we have Article 7 of the Treaty on the European Union to enforce that politically, at least. Of course, we have the possibility to use legal procedures in the treaties to target member states' action. Question is, of course, is that sufficient? And we have seen over the past years that this in itself may not be sufficient, so that new mechanisms have been put into place. So we have been studying over the past years also those new mechanisms. As such, we have had the attention to the rule of law mechanism. We've had Commissioner Reinders coming here also to talk in a broadcasted manner about the first rule of law report. I imagine the first rule of law report. We are talking 2 or 3 years ago, right? Isn't that something to reflect upon? Why do we now need a rule of law report to monitor member states, to name and shame member states, to try and get member states into a constructive dialogue and to stop them from backsliding? We also had last year the conference on the future, the Convention on the Future of Europe, democratic processes in action, to try and get all of this again on the rail. And today we are here to talk about a very recent, again, instrument and tool put into place, namely the rule of law conditionality regulation. As I said, we are very happy to have this panel discussion here today, organized together with EU Law Live. You all know probably also that the Commissioner Frans Timmermans was very also instructive in discussing and putting the proposal for this regulation to the table. Frans Timmermans and his cabinet, and I'm mentioning this because today normally Ben Smulders would have been with us, who is teaching the rule of law here at the college, and who, of course, takes this regulation very much at heart for having, and this is a historical fact, I think, for having been very much there when that instrument was also being elaborated. But it is not my task to explain to you what this regulation is, and in particular, how the Court of Justice assessed that regulation. We have prominent experts with us today to talk to you about that and to enter into discussion with you. And without further ado, I'm very happy to hand over the floor to the chair of the first session, Professor Sarmiento.
Thank you very much, Professor Gebere, for the presentation, your introductory words. I think it was a perfect framing of the topic that we're going to be discussing this afternoon. Now, my role here is to moderate the first panel, so I will limit myself to introduce our distinguished speakers and then welcome you all to raise any questions, both to our online participants and also to those who are here in person as well. We don't have much time. We have around an hour, so we'll have to be very efficient, and therefore the first one who should apply that is myself, and I will directly introduce our speakers. First of all, I have at my left Professor Stanislav Biernat, who is one of the most distinguished lawyers of Poland, who we are very privileged to have him here today with us. He is Professor Emeritus of the Jagiellonian University in Krakow, former head of the chair of European law at this university, and he has also been judge and vice president of the Polish Constitutional Court, founder and the first president of the Polish branch of FIDE, and author of an innumerable number of works, which I don't have time to recapitulate at this point. We thank you very much for being here with us and for traveling also all the way here to Bruges. And to his left, we have Alicia Sikora, Alicia, she has been for quite some time legal secretary at the Court of Justice of the European Union, which is the place where we actually met when we both worked there some years ago. But at the moment, she is legal advisor in the Council of the European Union and also a senior lecturer at the Faculty of Law of the Jagiellonian University as well. So Alicia has her two hats on, but today she will be wearing her academic hat. I must say that Alicia was one of the agents representing the Council in these proceedings, so she knows these judgments very, very well, but I insist she will be speaking on her personal capacity. And to her left, we have Pekka Poniakowski, who is also another former referendar of the Court of Justice, an LM from Harvard Law School, a former legal officer at the Finnish Ministry of Foreign Affairs, former judge at the District Court of Helsinki, at the moment researcher at the University of Helsinki. And I also want to thank you for traveling all the way from Helsinki here to Bruges today. And without further ado, with this very distinguished and plural representation of opinions and views of these two judgments, I give the floor to Professor Biermann.
Thank you. Thank you very much, the organizer, for invitation to the College of Europe, which has done much to promote knowledge of Europe, its law, politics, history, culture, and society. Two judgments of the Court of Justice of 16th February this year are very important. I will refer mostly to the Polish judgment, but they are almost identical. The second panel, the speaker in the second panel will be talking about more general implications of these judgments, but I will present some more practical approach to this question. I would like to reflect briefly on what the judgment may practically imply for the application of the December 2020 regulation on the rule of law conditionality. The judgment has removed the doubts as to the compatibility of the regulation with the treaties. There are therefore no longer any obstacles to apply its provision. I recall that the presidency conclusions of the European Council on the rule of law constitutionality in December 2020 stated that the Commission intended to develop and adopt guidelines on the way it will apply the regulation. Should an accent, and the conclusion said, should an accent for annulment be introduced with regard to the regulation, the guidelines would be finalized after the judgment of the Court of Justice so as to incorporate any relevant elements stemming from such judgments. The judgment has just been delivered, so it can be expected that the Commission will soon issue guidelines and then start investigation the rationale for opening the first proceedings. Already last November, the Commission asked Poland questions concerning observed violation of the rule of law from the beginning of 2021. The European Parliament has also strongly demanded that the Commission will take action even before the Court of Justice judgment. Let me recall in summary form recital 14 of the regulation. The Union has developed a variety of instruments and processes and promote that rule of law and its application, and provide an effective response from Union institutions to breaches of the rule of law through infringement proceedings and the procedure provided for in Article 7 TEU. The mechanism provided for in the regulation complements these instruments by protecting the Union budget against breaches of the principles of the rule of law affecting its sound financial management or the protection of the financial interests of the Union. In my contribution, I would like to refer to the statement and consider how the regulation complements the existing legal instruments. In other words, what is its added value? I want to point out that there is a wide divergence of view in Poland concerning the supposed practical effects of applying the regulation. Some expect the Commission to initiate wide-ranging proceedings against Poland in view of the breach of political power, of the independence of the judiciary, the political subordination of public prosecutors, and attacks on certain social groups. Other observers assume that the effects of the regulation will be limited and not expected quickly. I will try to present in this context a fragmented analysis of the regulation and the judgment. I will do so by first outlining in a nutshell the conditions for the use of previous existing instruments and then contrasting them with what emerges from the regulation and the judgment. The point is to establish when the various legal instruments can be used and applied. First, Article 7, which has already been extensively discussed in the court's judgment, so I will just devote one sentence to it as a reminder. The question is what criteria are used in particular instruments. And as far as Article 7 is concerned, the only, however, very important ground for initiating proceeding is the allegation of a clear risk of a serious breach by a member state of the values referred to in Article 2 TU. The Court of Justice in the last judgment talked a lot about the conditions of Article 7. And second instrument, as far as the assessment of the independence of member states' courts in infringement proceeding is concerned, the Court of Justice has stated in several judgments against Poland, for instance, in the judgment C192/18, that as regards the material scope, Article 19, paragraph 1 TU, that provision refers to the fields covered by Union law, irrespective of whether the member states are implementing Union law within the meaning of Article 51, paragraph 1 of the Charter. Every member state, said the Court of Justice, must ensure that the bodies which, as court or tribunals, come within its judicial system in the fields covered by EU law and which therefore are liable to rule in that capacity on the application or interpretation of EU law meet the requirements of effective judicial protection. So the scope of Article 19 is pretty broad. And now, for the sake of contrast, I would like to turn to the Rule of Law Conditionality regulation in the light of the last judgment. This is about establishing in what practical instances the Commission will be empowered to initiate and conduct proceedings, and the Council will be able to decide on legal measures against a member state. The importance of this issue is confirmed by the fact that the court specified the conditions for the application of measure under the regulation in more than 20 paragraphs in the whole judgment. These conditions are numerous and varied and must appear altogether, cumulatively. I will list them as presented in paragraph 288 on the judgment, just to show what conditions really are to be met. Thus, the Commission may initiate the procedure only when, 1, it finds that there are reasonable grounds for considering that at least one of the principles of the rule of law referred to in Article 2 of that regulation has been breached in a member state. 2, that the breach concerned at least one of the situations attributable to an authority of a member state, or at least one instance of conduct of such authorities referred to in Article 4 of the regulation. 3, insofar as those situations or that conduct is relevant to the sound financial management of the union budget or for the protection of the union's financial interests. 4, that the breach affects or risks seriously affecting that sound management or those financial interests. 5, in a sufficiently direct way. And 6, by a real link between those breaches and that effects or serious risk of effect. It follows from the above list that the conditions differ considerably from those recalled above for triggering the previous instruments provided for in EU law. The novelty lies in linking the infringement of the rule of law in very various ways with detailed and multifaceted impact of that infringement of the budget and financial of the union. The added value of the regulation in the light of the judgment is beyond doubt. It should be noted, however, that the interpretation of the above mentioned premises will not be easy, since the regulation, even after the judgment, in my opinion, leaves a certain amount of discretion to the Commission and then to the Council. Therefore, the issue discussed here is still open. Clarification of the contents of particular conditions will take place either in the guidelines or only during individual Commission proceedings. There is a widespread expectation that the Commission will soon make use of its powers. It is, however, difficult to predict when it will happen. I will only note here that extensive procedural rules contained in Article 6 of the regulation, which have been widely commented on in the judgment, concerning both the sources of information and the requirements to be met in order for proceedings to be fair. So not only the lot of premises and criteria, but also the procedural requirements. Finally, I would like to mention perhaps the first or one of the first cases against Poland that the Commission might trigger. The European Chief Prosecutor addressed a letter to the Commission exactly on the day of judgment on the rule of law conditionality, pointing at Poland's refusal to cooperate with the European Public Prosecutor Office, EPPO. Because Poland does not take part in the enhanced cooperation on the establishment of the EPPO, cooperation between EPPO and competent judicial authorities in Poland still has to rely on the existing instruments for judicial cooperation and mutual recognition. Poland has been constantly rejecting the EPPO's request for judicial cooperation since the start of its operations. Given that whenever the EPPO is carrying out a criminal investigation of a cross-border nature, it is unable to obtain evidence located in Poland. The EPPO's ability to counter criminality affecting the union budget is systematically hindered. The EPPO currently has 23 ongoing investigations involving Poland. So it's a clear example of the situation when the criteria of the regulation are, in my opinion, met. It's all. Thank you for your attention.
Thank you. Alicia, you have the floor.
Thank you very much for the floor. Dear professors, dear colleagues, dear students. I would like to warmly thank the organizers, Professor Govere, Professor Garpen, Professor Sarmiento, for inviting me today to this distinguished panel. It seems particularly adequate to discuss such judgments of principle in the College of Europe. These judgments illustrate constitutive and constitutional role of the Court of Justice in the EU legal order, and here in this place where so many young generations of EU law enthusiasts have been educated, it is relatively unique. Let me address first the conceptual meaning of the judicial decisions we are discussing today. And in order to illustrate the intricacies of the judicial discourse by the Court of Justice, I will refer to a particular judicial method which has been qualified in the doctrine of EU law as stone-by-stone approach. For the Court of Justice, a case-based reasoning and precedents, while performing a role of the classical prior decisions that function as models for later decisions, they operate also at a more profound layer and constitute fundamental constitutional tool for building legitimacy, both of the EU law as an autonomous legal order and also of the jurisprudence of the court itself. And this expression, stone by stone, which I like a lot, which is created by Professor Lennartz in his publications, also serves as the defining metaphor of my intervention today. Indeed, the two full court, I insist on that, it's full court judgments we are discussing today are fundamentally anchored in the recent jurisprudence already referred to by Professor Biernat, building the axiology of the Union. They codify and supplement rule of law, case law of the court on judicial independence and foundations of the EU membership, expounded notably in Portuguese judges, in Republika, in Romanian judges' case, and in Commission against Poland case on the Supreme Court independence. These judgments rely notably on the principle of non-regression and the fact that the compliance with the values contained in Article 2 TEU is a fundamental obligation related to the EU membership. The two judgments discussed today illustrate yet another and novel dimension of the EU legal order. And these novelties, according to me, oscillate around solidarity and constitutional identity of the Union. Let me first address the solidarity dimension of these important judgments. As recalled by Advocate General Bot in the also famous relocation decisions cases, Slovakia and Hungary versus Council, solidarity amounts to, and I quote, the quintessence of what is both the raison d'être and the objective of the European project. Rule of law conditionality regulation is about protecting EU budget, which provides the Union with the means necessary to attain its objectives and carry through its policies. As recalled by Advocate General Campos Sanchez Bordona in our today discussed cases, the budget of the Union is the instrument of EU law, which each year translates the principle of solidarity into the financial terms, and it is the budget of the Union, it is of constitutional importance. And the Court of Justice, both in Hungarian and Polish judgments, found very clearly that the Union budget is one of the principal instruments for giving practical effect to the principle of solidarity, referred to in Article 2 TEU. Furthermore, the court also judged that the implementation of the principle of solidarity through the union budget is based on mutual trust between member states in the responsible use of common resources included in that budget. The mutual trust itself is based on a commitment of each member state to comply with its obligation under EU law and to continue to comply, as referred in the Rule of Law Regulation recitals, with the values contained in Article 2 TEU. To conclude, what is important, in my view, in these judgments is that principles of solidarity is at the heart of the rule of law regulation, of the rule of law conditionality concept, which means that the EU budget is not just about financial operations. Rather, it enables functioning of a community of values through responsible use of resources based on a mutual trust and embedded in the solidarity among member states. My second point relates to an element which is presented by the court with an unprecedented clarity in the two judgments, since the court confirms the existence of a very identity of the union and the need to actively preserve its unity. I have to admit, I remember very well this very emotional momentum of the hearing when the Polish judge, Marek Safian, asked the Polish government representative a question whether they believe there exists such a thing like a constitutional identity of the Union, and whether the rule of law is a part of such a constitutional identity. We should recall that the Polish line of defense relied on a kind of conceptual exclusivity of the rule of law as expression of national competence and a question of national policy only. And the court is telling us in the two judgments that Article 2 TEU is not merely a statement of policy guidelines or intentions, but contains values which are an integral part of the very identity of the European Union as a common legal order, values which are given then concrete expression in various principles containing legally binding obligations for the member states. Since the concept of national constitutional identities was heavily relied upon by the applicant member states, the court equally addresses this point, very important point, by emphasizing that whilst they have separate national identities, obviously, the member states adhere to a concept of the rule of law, which they share as a common value to their own constitutional traditions and which they have undertaken to respect at all times. The court goes, however, a step further by adding another stone to the jurisprudential edifice of the Union, calling for a tangible constitutional activism regarding the respect of the rule of law and the unity of the legal order. The court is close, in my view, to a kind of militant democracy paradigm of the European Union. We are thus in face of a twofold concept of an axiological defense, I would say. First, the court is addressing at the member states, saying, since the protection of the rule of law is construed as an obligation incumbent on member states stemming from the membership, do protect. And secondly, it is addressed at the EU institutions, since the court confirms their right to defend the Union and its values, where the sound financial management of the Union budget and the protection of the Union's financial interests are at stake. Indeed, the court is saying observance of the principles of the rule of law constitutes an obligation as to the result to be achieved on the part of the member states. And the court is adding a very important unity element by judging that the respect of national identities under Article 4, paragraph 2 TU, a very famous article discussed at large extent during the judgment, as well as certain degree of which member states enjoy in implementing principles of the rule of law, cannot undermine the unity of the rule of law in its essence. So the core of the rule of law cannot be undermined. The court is saying it in no way follows that the obligation as to the result to be achieved may vary from one member state to another. On the other hand, referring to the institutions, the court is saying very clearly where conduct of national authorities adversely affects or risks affecting the sound financial management and the financial interest of the Union, the court is saying the European Union cannot be criticized for implementing, in defense of its identity, which includes the values, of course, enshrined in Article 2 TU, the means necessary to protect the sound financial management and financial interests by adopting appropriate measures, and the appropriate measure, of course, in the case at hand, it is our rule of law conditionality regulation. By way of conclusion, I would like to refer to one of my most favorite EU law philosophers, who is, of course, Pierre Pescatore, who convincingly argued in 1972 that the EU treaties are profoundly embedded in the teleology. And of course, I prefer his French text. And he was saying, les traités sont entièrement pétris de téléologie, since they are entirely founded on the concept of the objectives to attain. In today's rule of law conditionality judgments of the Court of Justice, what the court did is that within its mission under Article 19 TU, and following this stone-by-stone jurisprudence, the court is translating the objectives and values of the Union into the dynamic perspective of results to be jointly achieved and preserved. Thank you very much for your attention.
Thank you very much. Becca, you have the floor now.
Thank you, Daniel. Thank you to the organizers. It's a real privilege to be included in the panel with such experts. Many insightful points have already been made. Let me just add a couple more thoughts. So as a preliminary remark, I would say that with these cases, the Court of Justice has been in the spotlight like it very rarely is. The cases are unusual. We know the political stakes. There is no need to repeat them now. But both the procedural and, let's call it, extra procedural treatment has been quite remarkable. As was already mentioned, these cases were heard by the full court. At the same time, they were heard in expedited procedure. But also, they were unusually mediatized. We've had academics live tweeting the hearing. It's the first time the ECJ delivers judgment on live stream. So I would say that it's safe to say that the court is no longer tucked away in the fairyland duchy of Luxembourg that Eric Stein spoke about in the 1980s, crafting a secret constitution, but it's doing what it does out in the open. Against this backdrop of how the constitution building environment of the court has changed, I have 4 substantive points about the judgments. 1, the ECJ uses the idea of the EU's constitutional identity to justify a legislative act. 2, it clarifies member state obligations with regard to the rule of law standard to be observed during membership. 3, it confirms the legality of horizontal conditionality in general and with regard to the Article 2 TEU values in particular. And finally, it explains also how the European Council has no proper role in the process established by the conditionality regulation. So first, the EU's constitutional identity, it makes an explicit appearance in these judgments. The court indeed chooses to characterize the EU's values, the Article 2 values, as part of its quote-unquote very identity. This occurs in the context of the Hungary and Poland's claims, which essentially say that you can't create a financial conditionality regime where the condition is the respect for the rule of law. This is a claim essentially about the scope of Article 332, which is the legal base that was used. The court then says, well, Article 322 gives the EU the power to establish a financial conditionality regime, and this is clear. As for the rule of law as a condition, the member states, I quote the court, so they, as the masters of the treaties, have identified the rule of law as a shared value. It follows for the court that the EU must be able to use financial conditionality to defend the rule of law because it's part of the EU's core identity, which cannot be compromised. So the values in Article 2 thus become part of the justification of the use of legal basis. Now, it's interesting that Hungary and Poland brought these perhaps doubtfully motivated cases challenging the regulation with every federal constitutional law type argument that they could find lying around. But it seems that they get more than they bargained for, that the ECJ actually engaged fully with their claims. The court essentially says the Union has a constitutional identity which is built on the rule of law, and this means it must have the power to adopt measures to defend this identity if necessary. And by the way, this logic is not limited to the rule of law, but it encompasses all the Article 2 values. This leads me to my second point, which is member state obligations. So as mentioned, the court refers to the Article 2 values for support to affirm Article 322 as the legal basis of the regulation. And in this context, it says Article 2 values bind the member states not only on accession, but, quote unquote, at all times. This seems to me like a slight clarification of the obscure Republica test of, quote unquote, no reduction in the post-accession rule of law protection in a member state. The problem with the Republica test is that if you require no backsliding only in relation to the date of accession, does the required level of rule of law protection depend on when the member state joined? In the 1950s, 70s, 2010s, was the level truly the same in Sweden and in Bulgaria at the time of their respective accessions? And does this inevitably mean that the rule of law is different for each member state? Well, surely the ECJ didn't mean all that, but the test seems problematic. Here, the court is more, let's say, logical and states consistently throughout the judgments that Article 2 binds also during membership, full stop. What's more, the court says that the rule of law is a shared value for the member states and that all the Article 2 values are common to those member states and not only values of the Union. So this implies that the rule of law is treated by the court as in something of an EU law concept or EU concept, autonomous concept. It's then more or less the same for all member states. True, member states have a, quote, a certain degree of discretion in implementing the principles of the rule of law, end quote, notably based on Article 4, paragraph 2 of the EU treaty. But even if the rule of law is breached by a national authority acting within the reserved national powers, the EU can use conditionality to defend the rule of law. That is, if there is an effect on the EU's financial interests. This brings us back to the constitutional identity. The implication is that since the member states all share the EU's values, including the rule of law, there should not be a priori a conflict between the EU's identity and a member state's identity. But if there is, it seems the EU cannot compromise its own. Thirdly, and briefly, on horizontal conditionality. Important here is that the court refers expressly to, quote unquote, horizontal conditionality. This, generally speaking, means conditioning EU money on compliance with benchmarks which are not directly related to the use for which the funds are granted. These can be macroeconomic indicators or climate change goals, for example. This, to me, seems like good news for the future of horizontal conditionality measures. the court states that it is not even in dispute between the parties that the legal basis used by the legislature is fine to establish horizontal conditionality measures, as long as such measures are linked to compliance with a particular policy or goal of the Union. Then it goes further and says against the claims of Hungary and Poland that a horizontal conditionality mechanism is also fine when it specifically aims to protect the rule of law. So what does this mean? For now, it means that at least the existing horizontal conditionality measures are on solid legal ground and are unlikely to be challenged as unlawful by member states who might, for example, be unhappy about EU climate goals. For the present regulation, the devil is in the detail. It remains to be seen whether individual measures adopted under the regulation will be challenged before the EU courts and whether they survive, for example, a review of their proportionality. One final point on the role of the European Council. So if and when the Commission now proposes measures under the regulation, Hungary and Poland are likely to ask the European Council to debate the matter. The ECJ has now preempted some of this strategy by saying the European Council has no formal role in the process. As we heard, there is the recital, but the ECJ maintains very firmly that the Commission is in charge. Now, my point is that even if Hungary and Poland appeal to the European Council, as they probably will, the European Council can, of course, discuss the matter, but the Commission and the Council may act independently following the regulation. This should have probably been clear already before, but now the court has made it crystal clear. On that note, I believe I already said more than enough, so back to you, Daniel. Thank you.
Thank you very much, Becca. We have 6 minutes left before we go into the next panel. Do we have any questions here in the room or from our online participants who are also invited to send us questions in writing? We have a question here in front. Here.
Thank you. Thank you very much. I'd like to ask something that perhaps goes a bit beyond the judgment, but it's worthy to recall the context in which these cases arose. And it's basically because the European Council decided to not, or the Commission decided not to act based on the regulation until guidelines were eventually made, and those guidelines were going to be made on the basis of an eventual court judgment. So in this sense, this judgment brings the ball back to the Commission, which first has to develop guidelines on the basis of this judgment, on the basis of which later it will decide to act. And here my question is, the court seemed, at least in my opinion, to establish a high threshold in order for the Commission to act, in the sense that it has to prove that the breaches or the potential breaches of the rule of law have to be sufficiently direct. And in that case, not only these measures, or the measures that the Commission would potentially adopt, not only have to survive a proportionality test, but also it has to be established that they can affect, that the breaches themselves can affect in a sufficiently direct way. So my question is the regulation going to be potentially used in the future, or is it just a way sort of to provide with the EU with an instrument that can put pressure into Poland and Hungary to respect the rule of law?
Thank you. Do we have any other questions from the audience? Right, before I give the floor back to the speakers, I do have a point I'd like to raise, because it hasn't been mentioned so far. It concerns the identity of the Union. And I agree with the interpretation that Alicia has made of the judgment in the sense of a militant protection of the identity of the Union being there in the judgment. Now, the discussion about whether there is a constitutional identity or a constitutional core of the EU is something that's been quite present for quite some time. There's even been a discussion about whether there are intangible clauses in the treaty, right? And there are some references there, tacit references in the case law that actually exists. Probably in Cadi, we have the clearest example of that intangible core of the treaties. There is a very interesting article by Armin von Bogbandi and some of his researchers at the Max Planck Institute in Heidelberg, in which they supported that Ruiz Zambrano promoted an interpretation of European citizenship in connection with Article 2 that also went in the line of construing that constitutional core of the Union. So my question is, that very subtle evolution in the case law, how does it link with these two judgments from the full court, in which the notion of EU identity becomes very, 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 very prominent now? Is there a link, or maybe no? Maybe there's no link. That'll be my question to you. Before I turn back to our speakers, any questions from the audience? Okay, who wants to go first? Professor Biernat.
As far as the third question is concerned, it's the problem I tried to discuss in my intervention. There is a set of criteria, a set of requirements, and it's still open how they will be interpreted by the Commission. There is possibility that the criteria will be very strict, or practice will be very strict, and it will be bad, and it will mean that the judgment has no a result which was expected by the observers. But it's also possible that the Commission will find a formula which allows to, let's say, to punish, in a sense, the member states. Although I use this word punish, maybe not in a good sense, because in the whole judgment, the judgments, the Court of Justice stresses that it's not the question of sanctions, punishments, but it's the question of measures. But practically, they are, of course, sanctions, and the various interpretations are possible. In this, I admire the judgment in these general terms, especially this concept of identity of the Union, but the practical implications are still hard to predict.
Oops. Thank you very much for the questions. Very briefly regarding the first one, I think I can only support what Professor Biernat has already explained. We all know in which context this regulation was born. Of course, there is a whole rationale which stems from political choices undertaken by member states, and it's true that there is this, let's say, starting point, but the regulation is as such as a concept of what Pekka was referring to, the horizontal conditionality, is I would say a symbol of the development of the concept of conditionality as such. So the concept of triggering various benchmarks for the purpose of use of EU money. So we are making it more practical, more, I would say, transparent, more efficient. We want, through this instrument, to show that the use of the common resources is not a question of just reshuffling the numbers, but it is a common embedded in the solidarity construct. So I think it shouldn't be only seen as a kind of only politically driven instrument. And concerning the EU's constitutional core, I kind of avoided this because it's one of my favorite subjects and also subject of my research. And Daniel here published a fantastic article I read with lots of interest some time ago. And the EU's constitutional core, refers to this idea that we have, and not only in the EU legal order, but in each legal order. So in the core of the Constitution, there is something we cannot amend. It remains as something that has to stay, and it implies in EU law a new hierarchy of norms, because we would normally think of EU treaties as the highest, and no, what EU's constitutional core concept brings about it is that there is something above. And also Advocate General Kokot published a very interesting article in relation to the Charter, where there are certain components of the Charter wouldn't go then above the treaty. So there is we then refer to the new hierarchy of the EU law norms, and it's fascinating. And I have to say that myself, I am trying to defend the idea that because it doesn't contain, of course, many elements. We speak about democracy as rule of law, but myself, I actually would even adventure to argue that it could contain environmental protection in this new line of developments of where we are now facing in the European Union. Yet in the judgments, what I would say that the court kind of, to me, replied to this national perspective, this conceptual exclusivity, which was argued by the applicant member states. So of course, there is the expression, the very foundations in the judgments, but I didn't feel, but maybe it's because I focus more on this contrast between the applicants, I would say, rationale and what the court was trying to identify. And the question of the Polish judge I referred to about the existence as such of this EU's constitutional identity, maybe it goes to the direction, but I think that the court was kind of, intellectually speaking, a prisoner of this contrast that was brought about by the applicant. So to say that the rule of law only belongs to the member states. So the EU, well, you have it somewhere in the treaties, but you cannot appropriate yourself the value as such. We give it the content, we member states. So this was the discourse, and of course, which does not exclude that this very identity, and this very is very important, because it's not only identity, but it's very identity the court is emphasizing. I think it may be a step towards this EU's constitutional court, of course, more conceptual dimension, but I think here the court responded more to the precise argument of the applicants. Thank you.
Thank you. Becca.
As for the first question, I would say that the ball is in the Commission's court. Whether the regulation is usable, we'll have to see what the Commission does with it. For the second question, how do rulings like Cadi or Ruiz-Zambrano relate to these cases? To me, it seems that in those cases, the constitutional core is somehow perhaps not explicit, but implicit in the ruling, whereas here it is made explicit. And however, it's in reference to the values. And so perhaps the court could have still said values, but it chose to say identity, to go beyond in the constitutional lexicon. So perhaps it's the examples of implicit versus explicit constitutional core.
Thank you very much. Well, we're going to put an end to this panel here now, and we're going to go into the second panel to discuss the long-term prospects in light of the judgments. I'm going to ask our speakers to stay here with us, and our next speakers, because some of them are online, will be able to be here. So I also ask our next speaker to come forward. And we have some questions from our online participants, but since our speakers are staying also, our first panel speakers are staying here, we will leave some of those questions also for the second round of questions. And before we go into the second panel, I'd like to give a round of applause to our speakers once again. Thank you very much.
So that was a very brief break. And now we go into the second panel immediately to ask our very expert panelists and very distinguished speakers what they feel would be the long-term perspectives emanating from these judgments. I have a couple of questions myself in that sense, and I'll perhaps ask them up front to see if that will be incorporated in the speaking points. One of the questions that I was sort of having when I looked at those judgments and the whole history is the rule of law is not only meant to be protected by the courts. The rule of law is of fundamental importance for our democratic societies. So it's also the political institutions, but also the member states themselves that should step up. Now, this regulation could do that. But in the long term, will it take away the weight from the court? Or is it destined to emphasize again the role of the court? It's one of the questions that I have that I would like to see answered also by this panel. But without further ado, let me introduce our speakers. We have 3 speakers in the second panel, as you have seen. We have 2 speakers online, and we are very happy to have also one of our distinguished speakers who has joined us at the table. We have as our first speaker, who is online, and I don't know if you can see him here. He's not on screen. Can we see him on screen, perhaps?
At least I'm here.
Okay, perfect.
Now I think you can see me.
Hi, hello. I'm very pleased to welcome Professor René Repassi, who is a professor at the Erasmus University of Rotterdam, but whom, as you probably also know, is also a member of the European Parliament. Professor Repassi, without further ado, I will give you the floor. And if I can just remind people following us online that they can post questions during the talks also, and that we will try to bundle and reply to those questions during the Q&A session. Professor Repassi, you have the floor.
Yes, thanks. Thank you very much. Thanks a lot for being invited to this panel. And unfortunately, online, though the way from Rotterdam to Bruges is not that far away. But as a consequence of my new task, I'm a member of the European Parliament since the beginning of February. I had promised to my family, and I personally also want to keep this promise, that in so-called green weeks, the weeks when we are not in Brussels or Strasbourg, I stay with my family. And this is now my first green week. So on my first green week, I did not already want to break my promise, as I intend to also in my political work to keep my promises. So therefore grateful for having the opportunity to talk to you online, and also grateful that EU Law Live is co-organizing this event, where I'm part of the editorial board. But let's then go to the long-term implications that this panel is supposed to address. And I believe the initial question that was asked is indeed going to the core of this. What we have seen until now, and which from the perspective of the European Parliament we have criticized multiple times, is a rather inactivity by the European institutions, except for the European Court of Justice, who was very active in protecting the rule of law. And we know of the shortcomings of Article 70 EU that basically creates some problems for EU institutions. But we know that since the 1st of January 2021, there was no reason for the European Commission and others to hide behind unanimity requirements, because we got the regulation that now finally was declared legal, hardly to a surprise for anybody who calls him or herself an EU law expert. And as you know, the European Parliament has claimed multiple times that the European Commission should start making use of these new tools as of the first day of its entry into force. And this infamous political deal of the European Council meeting in December, by which the Commission committed itself politically not to make use of the regulation, or at least of the possibility to freeze funds until the European Court of Justice has decided on the legality, was never considered a barrier from our perspective. In legal terms, it wasn't a barrier anyway. And that was also now clear. So this judgment is, in terms of substance, not surprising, but of course in its details it has very surprising elements. So one that I find particularly striking, and excuse me that I came a bit later, so you might have discussed this also in the first panel already, is to link the rule of law in Article 2 with the characterizations of the societies in the second part of Article 2. So in paragraph 229 in the Hungary judgment, where the court says, although Article 2 TEU refers separately to the rule of law as a value common to the member states and to the principle of non-discrimination, it is clear that a member state whose society is characterized by discrimination cannot be regarded as ensuring respect for the rule of law within the meaning of that common value. So here we get a connection between rule of law and all the case law developed around it and the other values mentioned in Article 2, which this paragraph, I believe, has some potential for the future in order to make more use of this term. If you look at the regulation, I can only reiterate the urge that is made by the European Parliament that the Commission now finally starts acting on it. Now that the statement by Commission President von der Leyen that we only need to have first our guidelines and then we can start acting is already showing there's again some time that we are going to lose in this process. But okay, ultimately it is going to be used. We will see. The interesting question that is then now coming is going to be a tool which is going to be used broadly for rule of law issues, or will it be strictly on the budget? What we interestingly see in the judgment that they are very broad in their understanding of rule of law, but make clear that the application of the regulation to single cases is up to strict proportionality. That makes it that this very regulation, I believe, will be a budget tool, and more indeed one that is looking at rule of law issues related to the budget than a general tool. That's the first remark. So I therefore believe that courts will not be released from their leading role when we speak about the rule of law. Yet the EU can step up, but only so far as the rule of law conditionality regulation allows for it. What I find more interesting, and that is maybe something that also the next speakers could address, we do not only have, of course, the rule of law conditionality regulation, but we also have a link of any kind of appropriation decision to the general legal framework of the European Union. To which extent the general legal framework of the European Union does not allow already to us to make more use also of a broader concept of the rule of law, linking to payment decisions. Because we know also from research that the cohesion funds and other payments from EU budget are the tool that is going to hurt those countries that hijack their judicial systems. So what is possible in the general legal framework, I think, becomes interesting, and I do believe that the Court of Justice was opening the door towards these other paths in those two judgments. Let me conclude with a more general remark. We should also, let's say, we are all looking forward to paths to finally get some countries supporting the rule of law stronger than they currently do. But we should not forget one thing. We do only want to hurt those that, should be hurt. And this is not a civilization. So I do believe we need to reconsider how our cohesion funds are paid out. And we should more involve direct payments to civil society organizations so that they are not deprived from rule of law violations of member state governments, but that actually the European Union can directly interact also by means of funding with organizations that are on the ground, and not just speaking of minimal numbers, but of bigger numbers, so that the money stream of the EU not always has to be channeled via the governments, which basically makes the tool that they can claim EU funds for their own successes and strengthening their political positions. Let me conclude with a very last sentence. I honestly am today still highly under the impression of what is happening in the east of our continent. I do believe that there is a link between what we discuss here and what is happening there. Because the rule of law is an idea that derives from the idea of a community of law, of Rechtsgemeinschaft, that was created in order to manage conflicts between states and citizens in a legal way. And we want to make use of national courts in order to enforce European rules so that we do not have to fall back to violence, what we see in the very East. So in that sense, defending the rule of law at this level that we do here is precisely what we need in order to strengthen the backbone of European integration that was once created in exactly this manner to prevent from happening what we see in the Far East. Thank you.
Thank you very much. I hope you can stay with us for the discussion at the end of this panel. We have lost connection, I'm just informed, with the next speaker, Olivier Walbroek, on the program. So if Professor Zuzai agrees, I would propose to first ask him to talk about the long-term perspectives. Professor Zuzai is well known, of course, at the college. He's been a visiting professor for over 30 years, if I'm not mistaken, in the law department. As you all know, probably he's also with the legal service of the council, currently seconded to the Directorate General of the General Secretariat of the Council. So, Professor Zuzai, you have the floor.
Thank you, Inge. Thank you for the invitation and also the introduction. I'm very happy to be part of this webinar, which I think is a very topical and timely webinar dealing with the two rulings of the European Court of Justice, which I myself consider landmark judgments and not just constitutional value, but also historical. At the outset, I wanted to say that certainly what I will say is purely my personal capacity. It does not committee my institutions which I belong to. I wanted to, within this very short period of time, to say a number of general points concerning the two judgments and its broader and longer term impacts, and then to deal specifically with three additional questions. The first has already been mentioned, and that is this issue of constitutional identity or to protection of national identities in Article 4, Paragraph 2. The second has also been mentioned already to some extent. It relates the future decision-making process, and in that respect, the role of the European Council. And then, lastly, a notion which is very interesting in the whole context, and that is about the timely decision-making notion in the Council itself. Which term is used, the timely decision-making, under Article 6, Paragraph 10 of the regulation. So these are my contribution very briefly. The first is a general assessment briefly about the two rulings. The first is about that I think that this ruling, in my view, has not just confirmed the validity of the regulation, but it also gave a very detailed and well-elaborated judicial guidance in terms of the key constituting components of the regulation, which is very useful, very helpful, and should be welcome, in my view, concerning its future application. Just to remind you, the two rulings is almost 60 pages and 364 points. So extremely detailed, extremely long, and as already has been underlined, it has been handed down by a full court of the European Court of Justice. The general feeling which I have is that the court has actually given a very useful and very important interpretation of almost all the key provisions of the regulation itself. The court, first of all, has clearly underlined that what is the nature of the mechanism. And this is very important for a longer-term perspective. And I agree with those who already underlined that this is rather a budget defense instrument following the two rulings of the European Court of Justice. In this respect, I wanted to quote from the Hungarian ruling, point 353, a very important message from the European Court of Justice, namely that with regard to the nature of the mechanism, the court underlined that the contested regulation is not intended to penalize breaches of rule of law as such, but rather, as stated in paragraph 84 and 152, so a very detailed analysis which the court gave, to ensure the protection of the union budget. So rather, it intended to ensure the protection of the union budget, with the result that the argument that the contested regulation must satisfy the requirements eligibly applicable to penalty measures cannot in any event succeed. Because there was also an argument that this is practically a penalty or a punishment. We heard different expressions. Point 353 of the judgment makes it clear what is the nature of this mechanism. And I think this is extremely important for longer-term perspective and especially its future application. The third, I wanted to underline very briefly, I think that the court in this ruling really tried to defend the due process requirement concerning any future application of the regulation in concrete individual cases. In that respect, the court clearly underlined what is the task for the European Commission. So the European Commission really must do a very diligent, careful, objective, facts-based and evidence-based analysis before the Commission prepares a dossier concerning the activation of the mechanism. In this respect, the court clearly underlined also the principle of objectivity, non-discrimination, and the strict observance of the principle of proportionality, which the court really at length detailed in both judgments very carefully. That means that I personally agree that the Commission will analyze very carefully the first cases. So not the time factor is important, not the speed, but rather, in my view, from a professional point of view, that dossier be really fully compliant with those messages, those requirements which the court underlined in its very detailed rulings. In this respect, therefore, the Commission must be prudent, must really very carefully assess the first cases. And secondly, what is very important also from the court rulings is the constant dialogue with the concerned member states. So this is really an interactive process. This is really the concerned member states are really must be heard. And also, I think which is a crucial message for longer-term perspective from these judgments is that the main aim is prevention, is the preventive elements, and not the repression, not the repressive elements, not to penalize, not to impose sanctions on those member states who will be involved. And the graduality approach is also extremely important. So step by step, prior information getting, which the Commission already started last year, then the notification, the first stage, etc., you should read the judgments. What is the fourth message, in my view, that the new mechanism is a budget defense tool, but with significant possible impact on the whole rule of law issues which we are currently facing. In this respect, however, I would like to underline, and that is the message from the rulings, that these rulings is not a specific member states targeted. All member states can be involved under this mechanism. All the 27. In my view, and that is clear from the reasoning of the Court of Justice rulings to my reading, this is not just about Poland and Hungary. Any other member states can be involved at any time under the mechanism. And the court made it very clear in the two judgments that this is about all the member states, and that is, I think, a very important message for longer-term perspective. Having said that, I think that this mechanism, a very powerful instrument, in my reading, rather a budget defense instrument than a rule of law, but its significant positive impact on rule of law issues, but only in medium and longer term perspective. I think concerning short-term perspective, in my view, that is still the current toolbox, rule of law toolbox must be also used, and if possible, improved its efficiency. So we should not just wait on that this new mechanism will not solve all the problems. That cannot be the case, and I think we must remain realistic. There will be very important, the court rulings underline the importance of judicial review. Any council decision is subject to judicial review, and the court made it very clear. And in this respect, I expect huge litigations in the future on that. For example, the principle of complementarity. That's very important also in the regulation, but in the European Council conclusions of December 2020, the complementarity that the common provision regulation, for example, concerning the European structural investment funds, or the financial regulation instrument. So there should be an assessment in connection with that this instrument can be used just if the other instruments, and I quote from point D of the European Council conclusions, point 2, that the application of the mechanism will respect its subsidiarity character. Measures under the mechanism will be considered only where other procedures set out in union law, including common provision regulation, financial regulation, infringement procedures under the treaties, would not allow to protect the union budget more effectively. That is extremely important. Will not allow to protect the union budget more effectively. What does it mean? What does it mean more effectively? That is something in the future still to be detailed and more precisely defined. The last three special points. Constitutional identity issues. I think that it is really a very crucial part. Alicia and my Finnish colleague already underlined. I also love that part of the rulings, I must say. I already read at least 10 times. Because it is really such a fantastic, coronization of the last 3 years jurisprudence and how it has developed. Dear students and dear colleagues connected, there have been already at least 60 judgments handed down in this field. It's an enormous and extremely dynamic development which we can constate concerning rule of law protection. And in this respect, the court linked the whole rule of law respect issues to the accession process. There are several passages in the rulings talking about Article 49 of the Treaty of European Union. I have no time to detail, but I will have a long article soon published when you can read all about these issues. And second, and I quote, Alicia already quoted, 231, 32, etc. in the Hungarian rulings, it says one sentence. So it says the very identity of the European Union as a common legal order, you also refer to, but then it says that the member states adhere to the concept of rule of law which they share.
as a value common to their own constitutional traditions and which they have undertaken to respect at all times. That's the key word, is undertaken to respect at all times, not just when they exceeded, not just when they benefit from the Union, EU membership, but also at all times. And that is something which is also a moral duty for all member states. The European Council role, your colleague already referred to. The last one is the timely decision-making. The court gave a very detailed interpretation of Article 6 of the regulation, which is about the procedure. Please read it, it's extremely important. What I wanted to highlight here is the deadlines for the Council. The Council is the decision maker, of course, on a proposal from the Commission. But what is very crucial, that there are precise deadlines given. 1 month for the Council to decide, this is qualified majority on the proposal of the Commission. And if exceptional circumstances arise, the period for the adoption of the implementing decision may be extended by a maximum of 2 months. And then a nice thing comes in the regulation, and the court confirmed that, with a view to ensuring a timely decision. This is the first time, I am not a young man, when I see this wording, timely decision, in such a sensitive and politically extremely delicate dossier like we are talking about today. The Commission shall make use of its rights under Article 237 of the Functioning Treaty, where it deems it appropriate. So that means 237 of the Functioning Treaty, that the Commission can ask the Council to be convened. So the Council normally is convened by its President at the request of a member state and of the Commission. And even here is mentioned that the Commission can put pressure on the Council if the Council does not act within the given deadlines, can specifically ask for the convening of the Council in order to take the necessary final decision. Thank you.
Thank you very much, Jeno. And I'm very glad that in the meantime we have been able to connect with Olivier Waalbroek. So welcome also Mr. Waalbroek, who is Director of the Central Financial Service in the Directorate General for Budget at the European Commission. The Commission has, of course, been mentioned a lot. And we have with us the person in charge of the conditionality regulation. So without further ado, Mr. Waalbroek, we are looking forward to hearing your views on this, on the long-term perspectives of the conditionality regulation. You have the floor.
Thank you very much. I hope you can hear me well. Professor Govard, it's a pleasure for me to be with you virtually. I hope we'll be closer on other occasions, and it's also a pleasure and an honor to participate in this session. I will try to bring some practical angles to this discussion and maybe share with you some of our concerns more as an administration charged with the application of this new tool. This new tool, as it has been said, is fundamentally for us a budgetary tool. It's part of what we consider the budgetary toolbox. It's, of course, an essential addition to the means for the Union to protect its own budget, and also to promote rule of law, but it's first and foremost a budgetary tool, and I will explain more in detail why. It is also very much linked to its legal basis, of course. Article 322 of the treaty, as you know, which is the adoption of rules relating to the implementation of the budget. So it's important to remember that, because otherwise we could not have adopted the regulation in that form. It is meant to protect the budget fundamentally, and against what? Against the rule of law breaches. It has a complementary nature, as has been rightly stressed just before me. Why? Because we have already other tools at our disposal to protect the budget. We have the checks, the audits, the investigations of the OLAF, of the EPPO. We have as well the financial corrections, which are extremely important, in the context of the common provision regulations and the USIF funds. We have the exclusion system, which allows to exclude fraudulent operators up to 5 years from the benefit of EU funds. And finally, and not the least, we have the new horizontal enabling conditionality, which links the possibility for the Commission to pay expenditure to member states to the fact that they are effectively applying and implementing the EU Charter of Fundamental Rights. So we have already a range of possibilities, and we are adding a very important tool, which is the general conditionality. Another element that I would like to stress today is that this general conditionality applies not only to the EU budget, but also to the Recovery and Resilience Facility, which is, as you may know, a new animal in the arena of the relations between member states and the Commission. And this means that whenever a member state has a weakness in the protection of and the fight against fraud, conflicts of interest, or corruptions, or that there are issues of rule of law connected to the investments or economic reforms which are funded under this resilience and recovery facility, we have made, or we are making, of these weaknesses a special milestones and target in the national recovery plans, and actually the payment of the amounts to fund this reform will be linked to the achievement of the target. In other terms, if the target is not achieved, payments will not be made or funds will be recovered. This shows that actually it's not a matter of the Commission applying the regulation or not. Of course, the Commission is already applying the regulation. I will demonstrate how we are doing that in a moment. But by concluding by approving national recovery and resilience plans, which include targets with rule of law objectives, we are already applying this regulation, and we are already turning it in reality on the ground. This is extremely important because this facility has, as you know, a huge amount. It has to be implemented very quickly on the ground. It has to be implemented by the end of 2026. So it is an extremely powerful leverage to make rule of law a reality on the ground. And it is also a very much more positive agenda than the use of measures under the regulation. So let me stress this angle, because I think it's extremely important to show how we are combining all the instruments in our hands, depending on the problems that we encounter on the ground. Now, next to this budgetary toolbox, there is also a rule of law toolbox. will not recall this in details, but we have there everything from the European rule of law mechanism, the Justice Scoreboard, we have infringement proceedings, we have Article 7, and we have also the support to civil society, which is a key in the development on a daily basis of rule of law in our member states. Now, I will try to answer some of the comments which have been done up to now. You stressed, Professor Govard, the role of the court, or the courts, if I may say so. The Court of Justice will, of course, have a primary role in interpreting and judging the actions and the challenges, legal challenges, which will no doubt be brought against the decisions of the Commission. But not only not only the European Court, but also the national courts. Of course, the day-to-day judge of European law is, as we all know, the European judge, the national judge. And this national judge will have also to enforce this regulation and refer whatever problems application he or she is faced to should be referred to the Court of Luxembourg in order to have the normal dialogue promoting the application of this regulation. Then I take good note of the advice given to the Commission to be prudent and cautious and to build some cases. We are building some cases. This is why we are not rushing ourselves. We will not take more time than what is necessary to have rock-solid files, because we believe that we should not fail in the first decision we take on the basis of this regulation. Then I would like to develop a little bit as a final point of my intervention, the notion to know for whom this regulation matters. Is it a regulation for the member states? Is it a regulation for the citizen? Is it a regulation for the for the Commission or for the Court of Justice? It is definitely all of that, because it is about rule of law. And rule of law, as stated in the recital of this regulation, it is a relationship between the citizens and the institutions in an orderly manner, in a manner which protects certainty, security, and economic welfare. So it cannot be confiscated by one only. It is going to be used by the citizens to protect their rights. And there is a very special article in this regulation which refers to the need to protect the final recipients of funds, and that the Commission should avoid hurting them when adopting measures to the extent possible. It is, of course, a regulation also to protect the judges and their independence, their impartiality, and the functioning of the democracy overall in the member states. It is, of course, a tool for the Commission to protect its budget and to make sure that money is used for what it is meant to be used and does not end up in wrong places. And finally, it is, of course, an instrument for the Court of Justice to safeguard the European legal order, which is the overarching principle of our legal order, as you know. So, in a nutshell, this is the elements I would like to state as a first attempt to reply to your questions. Thank you.
Thank you. Thank you very much to all three speakers for your very pertinent interventions. You see, we've had three institutions talking. You will have the floor in a second, so you can prepare your questions. I would just like to mention the word toolbox, of course, has been mentioned several times, rule of law toolbox, also the financial toolbox of the European Union. Now, ideally, of course, once the house is built, you no longer need to resort to your toolbox. So long-term perspectives ideally would, of course, be that we never need to trigger this, right? And also when we look at whether it's to penalize, you said very well, it's not to penalize, it is to protect the budget. But if we take a step back, I would imagine that very much the idea is to put pressure, to be preventative. So I think we should not always look at it too closely, but also dare to take a step back and look at the long-term perspectives. And if hopefully we would never need to use it, that would be a sign that in fact it has been successful rather than the other way around. And from that perspective, personally, I was wondering to what extent the external events that we see today will in fact prove to be a very important external pressure, also to help ensure the rule of law so that we do not need to resort to our internal rule of law toolbox. So if something more positive could come out of the current situation, that might be part of it. But of course, the external context here has not yet been mentioned, but there is a question online about the external benchmarking with respect to the rule of law, and in particular, the checklist of the Venice Commission in the framework of the Council of Europe, to what extent that is an important benchmark that should also in the future be taken on board. Also, the Court of Justice refers to it in the judgment. So that is the first question for our panel, for our speakers, and all of our speakers, also from the first panel, are asked to intervene on this. And then we will turn to our audience. Do you have questions prepared that you would like to address to our panel to take on board? Now? No? Then I propose we first deal with that line of questioning. Who wants to take the floor first? And also our online speakers, of course, can just grab their microphone and speak up.
I will take the floor first, and then I have to say that I agree that the external factors are extremely important as well, and also the
the stability. The stability rule of law also gives us stability if there is rule of law within the European Union ensured. I wanted to say that, yes, indeed, the sources which the Commission may rely, that is very wide-ranging, and certainly the Council of Europe organs are very important, not just the Venice Commission, but the Greco recommendations. So there is a wide-ranging sources which the Commission can use, and I am sure the Commission will use. So as I know my colleagues, they are very precise, accurate, and professional in this respect. I wanted to take the last word in this Article 4, Paragraph 2 issues, because I think that that is very important for the longest perspective, namely this constitutional identity issues or national identity. I have to say that with Professor Biernat, we participated in 2000, so 22 years ago, in a congress organized in the Netherlands, in The Hague, in the Kurhaus Hotel, on the European Law Colloquium of the Netherlands, in the Usher Institute, and we were together, and at that time, before accession, it was in 2000, so before our countries joined the European Union, and I have to say that my contribution was about the constitutional acquis of the European Union in the context of accession. And before I came here, I read it yesterday, what I wrote 22 years ago, and I can just recommend all the students here and the participants to read. I think it was a lot of utility 22 years ago, what I put there. The European Council conclusions were mentioned, and I wanted to quote from point 2. The European Council underlines in December 2020 that the regulation is to be applied in full respect of Article 4, Paragraph 2 TEU, notably the national identities of member states inherent in their fundamental political and constitutional structures, of the principle of conferral, as well as of the principles of objectivity, non-discrimination, and equal treatment of member states. Quotation is ended. In this respect, it is extremely useful that the court elaborated on Article 4, Paragraph 2 at length in both rulings. And we already quoted that. But what I would plead for, even this evening in my personal capacity, that we need dialogue, because most probably some of the potentially concerned member states will refer to the rulings of their own constitutional courts. I don't want to mention any of them here this evening. How those constitutional courts interpret the national constitutional identity issues. And in this respect, we have now in the rulings how the European Court of Justice has interpreted it. And there might be really divergences. And in this respect, 2 days ago, the court handed down another very important judgment in a Romanian case called RS. And in that case, I wanted to draw your attention to the court called upon that if there is doubts about the meaning of Article 4, Paragraph 2, concerning supreme courts, constitutional courts, then they should refer questions to the ECJ. So practically, this was an invitation from the court to the supreme courts of member states, and including constitutional courts, let's establish a judicial dialogue. Because Article 4, Paragraph 2 is really a core. Because now what we see, there is not just constitutional identity of member states as interpreted by the constitutional courts, but there is also identity of the European Union, which is common and the key characteristic of each legal order. Thank you.
Thank you. Are there questions in the audience? Then you just raise your hand while you reflect on that. There are 2 questions bundled here from the online audience that I would like to put also to our panelists. 2 distinct type of questions. The first line is there any indication already of what the sanctions under the rule of law mechanism could look like in practice in order to be considered proportionate? How high will they be in terms of absolute numbers and or percentages of the funds allocated to the member state concerned, for instance, question mark. The second line of questioning goes in a different direction and says, in light of that external situation currently with Russia, won't the Commission be tempted to freeze the rule of law question for a while in order to keep Hungary and Poland on board regarding reactions and sanctions towards Russia? So 2 very different lines of questioning. I don't know if one of you would like to take the floor first. There are additional questions from the audience, I see. Let's first take that question as well.
Yeah, thank you very much for the contribution. So I have just a little question regarding the timing aspect, especially mentioned by Professor Weilbruch at the end, because if I understand it well, that is one aspect that was presented here as in favor of the new conditionality, that there are all these deadlines. But on the other hand, if I counted well, and we use all the extensions possible in Article 6 of the regulation, that would nevertheless amount up to 9 months to finish the procedure. And my question is, given that we already lost so much time in this rule of law crisis, that this might be even the core issue. I mean, there are people in Hungary, I recently read, saying that this is maybe the last shot there, the last democratic election soon happening there. Can we really afford to prepare well our first shot, or shouldn't we not just not lose any more time preparing guidelines, waiting to the Hungarian elections to have ended, and so on and so forth? Is that not the main weak point of this new rule of law tool again? That's my question. Thank you.
Thank you very much for that question. We have about 5 minutes left to give the replies to those questions and to one another. I would propose that we start with Professor Repassi, then Professor Weilbruch, and then the people around the table. So Professor Repassi, do you want to give an answer or a last statement for this panel today?
Yeah, thanks a lot for this. And once again, thanks a lot to EULAW Live and the College of Europe for organizing this seminar. And I basically would like to emphasize the question that was just asked from the audience, because this is precisely my own question. To which extent we are here still playing time now? There might be a real politics issue behind it, so I'm indeed curious to hear to which extent rule of law issues will now be toned down given the need for unity when it comes for action against Russia. But at the same time, I would also like to recall what I said at the end. We do see that our idea of rule of law established in the last decades is the backbone of our integration through law, or our community of law, meaning managing this kind of conflicts in a manner that does not resort to violence and things that we now see in the east of this continent. So I do therefore believe that these procedures have to be treated differently, and I can only urge the European Commission as the one who initiated, and later the Council, who is the one who has to ultimately approve it, to act quickly and not delay things any further. And I'm indeed curious to hear the answer to the last question from the 2 other speakers. Thanks a lot.
Thank you very much. Then we go immediately to Olivier Weilbruch for a 1-minute reply/statement, if possible. You are on mute. Yes.
Okay, fine. Sorry for that. First, the Commission is already applying the regulation. I mean, this idea that we are not applying the regulation, honestly, it's not serious. We have already sent information letter to 2 member states. We have shown that we are monitoring the situation in several member states. We are acting towards 2 member states, and we will take the next steps when the Commission considers that all the conditions are met. And believe me, we are working to build the best case possible, because we don't want our first decision to be annulled, simply. And I think it's in the collective interest that we make a reasonable and cautious use of these instruments in order to keep it alive. Otherwise, if our first decision is annulled, it will be just forgotten by everyone. And I would like to emphasize the dialogue dimension that has been referred to, and that will be my last point. That this dialogue is essential with the member states, and it has been called upon by the European Council themselves with these preliminary letters, these preliminary exchanges, and then all the dialogue through the procedure itself, which is meant to make the possibility to find an agreeable way forward, which is even quicker than the adoption of measures, which is only the last resort. Thank you.
Thank you very much. And then I go down the line, if you agree, Professor Biernat.
There was first the question about the external pressure, external context of our discussion, and then the additional question concerning the probable behavior of the Commission in this situation. So my general remark is that in this situation, which is taking place now in Ukraine, as a matter of fact, we don't know what's happened now. We are sitting here and we don't know what's going on. But it shows, I would say, that the hierarchy of values is completely different now. Now the most important situation is the sovereignty of the big European country and independence of this country, and the lives of thousands of millions of people. In this context, our discussions seem to be minor and not especially important, although there is a link, of course, because in such a situation, the unity of the Union and the Western world, I would say, NATO is especially important. And in such a situation, especially member states of the Union should stop making steps which are, as a matter of fact, against the unity, and which are dangerous for the status of the Union as a whole, as an actor of international relations, and they should refrain from breaching the rule of law. What could be the reaction of the Commission is hard to say. Saying that, okay, in this situation, Hungary and Poland can do what they want, would be very dangerous. Thank you.
Thank you. Indeed, the rule of law and the rule of international law, the respect of that is very much in danger currently. Alicia Sicura.
Thank you very much. I would like to share 2 final remarks. One is more to the point regarding the practical effect of the rule of law crisis or rule of law debate we are having in the EU legal order. And one is more general about the unity and the rationale of the community in which we are all today. First, I would like to refer to the recent judgment of the General Court. In this case, EPPO versus Commission is a case of the General Court. It's T791/19, and this is one of the first examples of the General Court examining the impact of systemic and generalized deficiencies in the rule of law in a member state, it is in Poland, on determination the competition authority is best placed to examine a complaint. So the applicant was arguing that what was not taken into account by the Commission in this competition procedure examination was the status of the authority, a national authority in the process. And it is true that this the General Court annuls the decision of the Commission rejecting a complaint of this of the operator. And here we can see the practical dimension, practical effect of the rule of law debate in various domains. So we are beyond budget only. We are now in a really completely different but still crucial domain of EU law. And more generally, I just wanted to close or take into account all the aspects we have discussed today. I wanted to come back to the very beginning. Why are we even in this community? Why this community was even created, and why countries consecutively were aspiring to become members of this community? It is precisely because it was about peace and rule of law. It was integration through law. It was the aspect, it was a response to what has happened previously and what we do not want to witness anymore. And this is my main message. Thank you.
Thank you, and a very important lesson. Pekka?
So on the impact of the external situation on the internal rule of law situation, EU membership is of course a package, and member states, when they choose to do so, then they have to deal with the external challenges also together. The question is, and assuming that there is first unity towards the outside on the challenge that is now there, will this then be reflected on the internal forum as unity on different issues, although perhaps on some level related? I'd like to maybe point out that there's at least why it can be difficult to assess or give a straight answer is that there are procedural differences. As we know, the foreign policy is intergovernmental. The rule of law has a lot of institutional players. If there were a silver lining, this of course could be it. However, I think that in light of today's actions, that's very much too early to say. It mostly looks like we have rather more problems, and I have to say that what one question implied, that the possible solution to the rule of law situation in these conditions might be indeed to kick the can down the road because there's something more pressing at the moment.
Thank you. I don't think there's more things pressing than the rule of law, whether it's internally or externally. Jeno, can you, in 1 short minute, conclude your thoughts on this?
Yeah. I agree with very briefly with Professor Biernat concerning the current situation. It's peace and security, which is our utmost interest. And I think that, as we heard from Olivier Verbroek, the Commission is doing its job as defined in the 2 rulings, and also the regulation requires. And I am sure that the rule of law situation will also improve in the European Union. But the most important is what Professor Biernat underlined, peace and security, and to respect rule of law in international level and under international law.
Thank you, and thanks, a very big thanks to all of our panelists for these very insightful comments. And without further ado now, I turn to Professor Sasha Gerben, who is the permanent professor in the Law Department of the College of Europe, to try and give some conclusions to this very pressing and urgent problem. Sasha.
Thank you. Good evening, everyone. So indeed, it is my privilege to try and draw some conclusions after the very interesting and eminent discussions that we've had. And obviously, any such conclusions will be premature because, first of all, the dust really has not settled on these rulings that are landmark, that are long, that are rich, that are constitutional, as Professor Chutai said. And were only rendered last week. And also because, as many of the speakers have underlined, this is a very dynamic and volatile issue, constantly developing in legal and political terms. A lot depends indeed on what the European Commission will do next, what it will not do. Anything in that regard is probably going to be subject to further legal actions. So obviously, I could not promise anything by way of a firm conclusion to you here. At the same time, I do think that some things emerge already quite clearly from today's talks. And that is that we, I think, all agree with the court. Maybe for once, I don't know. We all agree that it upheld the regulation with the rule of law conditionality mechanism contained therein as validly adopted within the EU's powers. And that was indeed not surprising, as Professor Repassi also said, but it is still noteworthy, also because, and it may be a bit provocative, this type of action that the EU takes on the basis of its powers in one area, namely the budget funding, to intervene in an area where it does not have a direct competence, namely the rule of law internal in the member states, can be mentioned as an example of competence creep. It is indirect legislation. Now, of course, as has been underlined, there needs to be a direct link. Trajan said this and various speakers as well. There needs to be a direct link between the threat to the budget and the breach of the rule of law and then the freezing of the funds connected thereto. So it's not a blank check to now fully regulate the rule of law internal to the member states, but still it is the EU intervening. I'm not saying interfering, I'm saying intervening in this area in an indirect way. Now, as opposed to perhaps some other forms of competence creep, this indirect legislation is still legislation. It is still used the community method. It has still involved very actively the European Parliament. So I think that the democratic concerns that are often connected to competence creep are not so poignant here. But I still find it somehow a little bit regretful and unsatisfactory that the EU has to act on this issue that we all agree and that the Court of Justice itself in the judgments also says is core to the constitutional identity of the European Union. And that then the EU institutions, you know, in all good faith, are scrambling somehow for ways in which they can act on this in the margins, indirectly, and a bit meagerly, to be honest. Yes, stone by stone, but I think we all agree that this is a particularly solid stone that the court has produced again. But there, I don't think, is a house built of these stones. And that's also not what the court can do. And it's not even under the current treaties what the EU institutions can do. And that's because there is no direct competence for the EU to really act on what is its own constitutional identity. It cannot really directly, openly, for the citizens of Europe, defend, flesh out the Article 2 values. The EU Charter of Fundamental Rights, which I think should be or could be a main vehicle for this, does not apply to the member states outside the scope of EU law. Now, as Professor Biernat, I think, expertly demonstrated, these judgments go some way towards giving, further scope to enlarge the scope of EU law in this respect. And yes, the court is doing, I think, all it sort of can to try and give a kind of mainstreaming effect to the values in Article 2. But when the court very commendably and admirably says that, Article 2 values are not just something that exceeding candidate countries can sign up for, but then completely disregard after they have exceeded, I'm sorry, but that is precisely what they can still to a very large extent do, and that's precisely the problem. So that, for me, is a bit of a sobering realization. I'm not trying to dismiss the relevance of these rulings. I'm not trying to dismiss the fact that, admirably, quite an extensive toolbox indeed has now been developed. But I don't think we're there yet. And so the Conference on the Future of Europe, I think, really should take this into account and should dare to do more democracy, as Professor Nemitz, who's not here, but who's also, of course, been very active on this theme, has argued for. Dare more democracy. So the Conference on the Future of Europe should really, I think, look into this. Also because, as many speakers, I think, also already underlined, this really, unfortunately, is not a problem that is limited or specific to Hungary and Poland. Let's be honest, I'm sorry, the problem is far graver. When we, of course, I don't try to downplay the gravity of the situation in those two member states, but the threat to constitutional democracy that lies in a diminished faith by citizens in central constitutional and democratic institutions, an increasing apathy and cynicism in part of the citizenry, and a rise in populism, that I guarantee you, it also occurs in the original founding six. This is not a accession, pre-accession, post-accession problem. We are seeing that across the EU, in my own member state, the Netherlands, for instance, as well, very much. So that only makes the problem worse, because it seems that a lot of these tools in the toolbox are only really useful, or they come into play, when the situation really has gotten out of hand already completely. So, yeah, I welcome the judgments. They are, in a way, a bit of a victory, or in any case, they offer new instruments for the EU institutions, try and force a breakthrough in the rule of law backsliding dossier. But they feel a bit hollow and as a Pyrrhic victory at the same time. And I mean, that sense of tragedy, to me, it only worsens. Yeah, I'm super cheerful today. When you shift the focus a little bit away, as I think Professor Sarmiento was doing with his question on linking to the European citizen and citizenship. So away from this as a battle between governments and an intergovernmental quarrel, rather looking at the situation of the European citizen. So where does all of this now leave the European citizens of Hungary and Poland? Because they are already tragically in the situation where they are subjected to being deprived of their Article 2 values on a daily basis by their governments. The constitutional promise, I think, that Article 2 makes, that the treaties make to them, cannot be fully fulfilled, because ultimately the current legal and political structure of the Union gives precedence to a contradictory constitutional promise to the member states of divided competences, and that there are areas that are internal to the member states, such as fundamental rights, the rule of law, and democracy. So that is already their situation. To add now insult to that injury, they may now be deprived of the funding, the financial support, the financial solidarity that they are, I think, entitled to as European citizens. And I have a slightly different interpretation of the principle of solidarity than the Court of Justice does in these judgments. Because for me, it's not really about member state versus member states, and that the rich ones should be, should show solidarity with the poor ones and give some payments, but that the poor ones really need to stick by the rules in order to qualify for that. I think that the citizens, the European citizens of Hungary and Poland and all other member states, they are already engaging in what I have called in some work the first act of solidarity, that is to participate in this project. They are not all winners in this project. Many of them can be losers in the internal market, and in any way, even if they're winners, they take part in producing the benefits of the common scheme that is the internal market and that is the European Union. That in itself, that participation is their act of solidarity. And in return, yes, they are entitled also to a fair share of the benefits that a common project produces. That's how I see the funds. I don't see them as charity handouts. And the conditionality element connected thereto, from the citizen's perspective, I have some difficulty in, even though I fully understand it from an inter-member state perspective. So, in that regard, I would like to fully subscribe to the proposition that was made by Professor Repassi that there needs to be, at least alongside any freezing of funds, there needs to be a tripled or quadrupled down investment in civil society organizations that are working in the EU member states and transnationally on the ground to try and fight this problem at the very roots, and that are working with civil society organizations very much under pressure in Hungary and in Poland, and to try and support them. And when I looked into this, regrettably, from what I saw, and maybe I'm mistaken, but I think that there are hardly any EU funds going into this. Instead, it is the Norway grants. It's Norway who is doing that for us. So maybe that's some low-hanging fruit for the EU to reach and to reap. And that might be a constructive way forward. That's it. Very good evening.
Thank you very much, Professor Garben, for giving your views and concluding remarks. I would like to give as last end word again my appreciation to EU Law Life and Professor Sarmiento for having made this joint organization possible. Thank you very much. And I hope that in the future we can collaborate again. And again, also a big thanks to all our panelists and all our speakers. So I think a last big hand for all of them is also in order.